This morning was the date set for the first hearing of the substantive matter that is before the courts. As you know, previously the Chief Justice had made an injunction order, and there were two grounds that we had applied under. One was that the special agreement is unconstitutional, and therefore we should stop the referendum. And the second ground was that the writ itself was defective in that it did not fall under the requirements of the Referendum Act. The Chief Justice had ruled on the second limb and granted an injunction based on that. And so the second issue, which is the constitutionality of the special agreement, is now currently before the Court of Appeal. And we go there on Thursday to address the case management conference moving forward on that point.
Did the party expect the government to file an application to discharge the injunction because of the new bill and because the date has passed?
No, not at all. We hadn't gotten any information from the government until this morning when I showed up at court. My learned senior, Ms. Schumann, indicated to me that they wanted to apply to discharge the current injunction that is in place. As you know, our clients were not required to be here today, so I haven't had an opportunity to consult with them to get their take, and also to consult with Senior Counsel Amon Courtney because he is currently before the Senate. And so the judge quite rightly and properly set that as a separate date, not to be heard today, but on the 29th of April.
As you know, the injunction was placed on very specific writs, and it enjoined the proposed referendum. Now, in the head note of the case, the proposed referendum has a date, April 10th, 2019. So what we are saying to the court is that this is not an open-ended injunction. It was meant specifically to stop the holding of the April 10th referendum. That is not in question or an issue any longer, and we therefore believe the injunction should be discharged. So he will hear us on the matter on the 29th of April.
In terms of the substantive matter when it comes to the referendum, I think the Prime Minister explained last week that it's date specific as well, yes. The writs. So how does that play in terms of the first hearing scheduled for the 29th?
Well, this is the point. If the writs on which the injunction were given were date specific and meant for specific writs, those writs are no longer in existence right now. So what are you enjoining? There's no referendum being held under those writs. And in fact, there are no longer any writs. They've expired. So that would be the heart of our contention.